Hello and welcome back to At Your Pace Online's Michigan Real Estate Education Series. This section of the class will examine property management and the relationship between landlords and tenants. We'll begin with a discussion of the essential aspects of the property management relationship. After that, we'll talk in depth about leases. Then we'll take on the subject of tenant relations. From there, we'll examine anti-discrimination regulations that affect landlords, property managers, and tenants. The class will end with a look at two Michigan laws, the Landlord-Tenant Relationship Act and the Truth in Renting Act. When most people think of real estate agents, they imagine the person who guides clients through the process of buying or selling a property. But there's a whole other side to the business of real estate, and that's where the property manager operates. We've mentioned leases and rentals before, but we've never really discussed where the real estate agent fits into this. Real estate agents do help with finding properties and potential tenants. Then they also help negotiate lease and rental contracts. Property management is a third way for real estate agents to be involved in this aspect of real estate. Property managers exist to assist property owners in doing all the work necessary to successfully rent or lease properties. This can include collecting rent, maintaining properties, obtaining new tenants, dealing with tenant issues, evictions, and following the law. The laws governing property management are sparse enough that property management contracts need to be robust and secure. The contract itself will contain the requirements for action. As a property manager, you'll have two primary considerations when making a property management contract. The first is whether the contract covers everything you need. This is where a real estate lawyer comes in handy. Go over the contract with an attorney or have an attorney write one for you so that you understand exactly what the contract entails. The last thing you want is to sue a landlord for breach of contract only to discover that the contract didn't prohibit the act the landlord committed. The second consideration is that you must understand the contract well enough to explain what it means to your clients. The method for gaining this understanding is the same as I said before. Talk to an attorney. But the purpose is very different. You always want to let your clients know that they should consult an attorney for specific contractual questions. However, a client will not be willing to sign a contract if you can't explain any of it to them. So, you'll need to explain it properly. That involves clarifying what your duties are and what their duties are. The purpose of this is to make the client feel that you're competent to manage the property. When you describe the agreement, you'll need to be careful that you're accurately describing it. If you say that the contract stipulates a certain process, when in fact the contract stipulates something else entirely, you can possibly be held liable in court. This shouldn't scare you away from explaining anything. Instead, it should make you pay attention to understanding what you're talking about before you talk about it. Once you've become a property manager, you'll be placed between the owner of the property and tenants renting space in that property. On one hand, you're the agent of the owner with all the duties and responsibilities that come along with that, and on the other hand, you're going to be the primary point of contact with the tenants. They'll come to you when a problem arises. An effective property manager will be able to balance these two sometimes competing interests. Now that we've established what a property manager is, we'll review agency responsibilities from the perspective of the property manager.